Hi, everyone. Good morning, and thank you for joining us for HR in half an hour. As you saw in the first slide, we will send out a recording of this presentation, and feel free to drop your questions in the questions and answer section, and we'll answer those at the end. And if you have any specific questions about an individual, you can reach out to our HR consulting team. So let's get started with a poll. When it comes to termination at your organization, what would you say is your biggest challenge? Is it documentation, manager hesitation, fear of legal risk, or all of the above? So I'll give you a few minutes to answer those questions. See what comes up. Okay, let's see what our results are. Okay, looks like we've got a mix in there, but documentation's starting to lead the way with looks like all of the above is taking a big lead there. And certainly documentation is important, and we're going to talk about all of these things as we go through the presentation. But it is important to add up all the little consequences of keeping an employee as we go through these things. So having said that, let's jump right in. Today, we're going to focus on when termination is the best option and take a closer look at how we get there while making it as fair as possible. And every termination comes with some risk, and it could be an employee claiming that they were wrongfully terminated or retaliated against for some unlawful reason, or even other employees quitting because of poor optics. And one thing to keep in mind as we go through this topic is that every organization is going to have different standards, different values, and every organization is going to have a different level of risk tolerance. So first, we're going to look at some just common scenarios of how do we get here where we think that separating might be the answer. Making this decision is never easy. We, of course, have concerns about the personal impact to the employee and their family, and we worry about the impact of the rest of the team that remains. And we know that there's going to be consequences to our customers and to our business. And as we've mentioned, terminations come with the risk of litigations. And so even though California is an at-will employer, we do want to enter thoughtfully into decisions like this. So let's first take a look at some of the most common scenarios where separation might be warranted. And the first one is just red flags right from the start. So let's say you've just hired someone. Chances are they're putting forward their very best foot in those first few months. So if you're seeing in those first 1, 2, 3 months that their work ethics don't match up with your company's work ethics, or maybe they don't know all the things that they said they knew during that job interview, or perhaps they're unreliable, this might be the ideal time to part ways. You've invested a little time in their training and money, and there's also a chance that they still have applications out there with other employers, and they're still looking at other jobs, and the relationships just haven't been fully formed with your team and your coworkers. So it's a good time at the beginning sometimes to make that decision. The most common reason that employees are let go is when they're underperforming over time and it's taking a toll on your business or your customers and the team that they work on. And of course, you have a duty to try and make improvements when performance isn't there, because turnover is very costly, but so is keeping a poor performer. So you often want to look at the potential loss from any mistakes as well. Some other things that can lead to separation might be misconduct, such as behavioral issues. Those could be things like fighting, stealing, threats of violence, and things like this can be so serious where you might part ways even without a warning. This is rare, but it can happen. There are also things like policy violations that could be so serious that where they cause such a great loss to your business or a customer that it could warrant termination. You might also have a situation where you need to part ways because of a substance abuse situation. You do want to be really careful with this one because addiction could be a covered disability, but being impaired on the job is not protected. And in ideal scenarios, this would be remedied with FMLA or CFRA, but it can result in termination if the employee makes the choice to report to work under the influence, or even worse, they're under the influence and something goes wrong. Another common scenario would be just misaligned values. And you hope that the employee self-selects out and finds another opportunity in this case. But if the values don't match up between the employee and the employer, it just makes it hard to find a way forward in those circumstances, no matter what behaviors change. And then lastly, there might be times where you just don't need that job anymore. And I'm not talking about mass layoffs, just maybe where you have one position that just is no longer needed in your business. So those are some of the most common reasons why an employment relationship might dissolve. So let's now say that we have one of those scenarios and we're ready to assess if this is the right time to terminate and how much risk might be associated with that action. So everything we talked about on the prior slide is what we would consider a termination for a cause. However, when those reasons are combined with other factors, it can present costly legal risk to the organization. Specifically, a claim could be made that they were not terminated due to poor performance, misconduct, or a layoff, but they could say it was due to discrimination, retaliation, or some other unlawful reason. And this is where you might want to consider stepping through the process with your labor law attorney. And just like we couldn't cover all the reasons why you might separate with an employee, we can't cover all the risk factors that you need to assess when faced with a termination, but these are some of the most common risk areas that you want to look at when you think it might be time to part ways. So a protected class, this is a group of people who are legally shielded from discrimination in the workplace. And there's 15 of those in California. So I'm not going to read off all of them or go into detail about all of them, but I think many of you are probably familiar that these protected classes are things like race, color, national origin, sexual orientation, family status, things like that. Another area that you want to consider are things like whistleblowers. Those would be things like if someone maybe had just reported your restaurant to SLO County Health Department, or perhaps you're a construction company and a safety complaint was just made. There could be other types of protected activity happening at the same time involving that employee that could be considered a risk factor. Like maybe they're talking about their pay with other coworkers to see if it's fair, or maybe they requested a leave of absence, or perhaps they're even on a leave of absence, or using protected sick time that they've earned, or maybe if they are asking for a reasonable accommodation due to some disability. All those protected activities combined with some of those other legitimate business reasons can present risk. Some other things could be things like work-related injuries. Did they recently sustain a work-related injury, or are they in the middle of a return to work program? Maybe they're on modified duty. And then one of the other things that you often hear in HR talking about the documentation. If you think you're ready to separate or not separate, you really want to take a look at the documentation. So say, for example, you have the performance issue. If the person is not performing, solid performance management with the documentation to back it up is important. For example, if an employee has been performing poorly for a long time, and the manager has been pointing out mistakes for that long time, and that's the extent of it. The manager has now set the expectation that this level of poor performance is enough to keep your job for a long time. But what we would expect to see is some documentation of coaching and then some formal counseling and clearly documentation that put the employee on notice of what was needed to change to keep their job. Likewise, if you were considering releasing an employee for something like misconduct, you would expect to see that there was documentation of an investigation that was formal, conducted by a trained investigator that supported that decision. And then lastly, if you're thinking about entering into separation, you want to make sure that you yourself have a clean house. Think about all the circumstances if that person were to bring litigation. Are you thinking about all your own wage and hour law practices? Is your timekeeping system accurate enough to make sure you're capturing all those meal penalties? Do you have a bully or a yeller on staff? Or just considering any legitimate legal claims that could arise if you have some legitimate risk factors that are present, you want to be sure and think about if you need to consult with an attorney. So if you still think you're in a good place, then the next thing is you really want to sit down and think about checking your facts. And before you go into a termination meeting, you always want to really be sure that everyone understands the employee's side of the story. This is something that is often overlooked because it's usually in an attempt to not tip off the employee that the separation is coming, but this can result in some really unexpected, unpleasant results if you go into that meeting and the employee comes up with some wildly good explanation that they can prove as to why they did what they did. Or maybe they add information that just changes everything and you realize that you shouldn't even be in that separation meeting. And if you're relying on some other leader to collect this information, get that employee perspective, make sure you yourself have actually asked that leader, what did that person say when you asked them about the situation? So you really want to vet that out well. You also want to know what's in the file to make sure that the timing is right. How long have they worked there and what has their performance pattern been like? And what is actually in the file? Is there current, clear documentation of expectations being set and not met? Was it made clear in writing that there would be consequences for not improving? Or do they look like a star employee that has rave reviews and they have merit increases year over year that somebody who didn't know this employee might wonder if they had a performance issue? And you also want to be sure and meet with the employee's direct manager. This is the person that's most familiar with the employee, their relationship with other people, their work product, and any outside factors that nobody else might know. It can also lead to the discovery of any missteps that the employer might not have seen. A great example would be if you're about to release somebody for, say, an attendance issue, and then the supervisor tells you that the employee has been telling them that they've been oversleeping because they're on a new medication for a heart condition. Well, then maybe they missed an opportunity to go through the interactive process, and this really was not an appropriate termination. And then also too, just if there's a next level manager, like you've got a supervisor and then the supervisor's manager, I think it's a good practice to involve them as well, just to make sure you have the full picture of everything that's happening between coworkers and just together you're discussing all the risk factors that we talked about on that previous slide and anything else that you might be aware of or that everyone involved might be aware of to be sure that you haven't overlooked any reason to bring in legal counsel or risks. And if you think you've vetted out all these other things, then it is time to move into our next slide. And we're going to review and confirm our decision. And this is where in addition to looking at legal considerations, you want to consider the fairness of the termination. And this is where you're looking at things such as the severity of the issue, like what really happened. Does the punishment fit the crime? What was the loss or the potential loss to your company? What was the impact to your customer? And what kind of opportunities was this person given to improve? And were they given additional training or help? And what do your company policies say? Did you follow them? And how do you normally treat similarly situated people? Is this the way you always respond when this happens? What does your history say? And I think that before you go into a meeting like this, you always want to be clear on the reason for separation. And it is true, California is an at-will state, and you can use that
Earthquake
as a
drill.
reason.
Earthquake drill.
Sorry, we're having an
Can
earthquake
you hear?
drill. Uh, but if you do use the at-will reason, just keep in mind that you are leaving a blank canvas for an attorney to paint their own story, and that may oftentimes not be in your favor. So once you have really just confirmed that this is everything, the next step is preparing for logistics. So the next part would be thinking about when you want to do this. When is considering things like, are there any company events happening that day? What do the pay dates fall on? What are the work schedules happening that day? What are the availabilities of the supervisor? Um, do you need time to cut their final paycheck and get it to them? And just as a reminder, final pay, if it is involuntary, is due immediately at the place of termination when it's not welcomed by the employee. And all wages are due, including any unused vacation or PTO. And any direct deposit agreements, they terminate when the employment terminates. So if you use that direct deposit method, you want to authorize a new direct deposit form. And it's not usually recommended to mail final pay, but you might have to if the remote employee, if they're remote or they request it. And then you want to just document that request and certification of receipt. You also want to think about who is going to be in this meeting. Ideally, that's going to be the person's manager and a witness, which would be HR if you have it. If not, another member of leadership. And you want to think about where. This should be a private place and ideally where they show up to work. It could be a home office if they work remotely and they're fully remote. Or for some reason they're not available to come to the workplace. And you also want to plan out any security scenarios like information technology access, building access, job site access, thinking about if they have keys to different buildings or job sites. You want to think about their personal belongings, if those need to be gathered in advance, or how those will be returned to the person, if they're going to be shipped, if they're going to be picking them up, how, when, where, how they're going to get to the employee. And then lastly, if you think it's going to be helpful, you could plan out what each person is going to say. You want to be brief and kind, and I like to speak softly and do my best not to get emotional. You want to state the reason why you're meeting, what's happening and why. And you want to be prepared that that employee could be defensive and emotional, but you don't want to just linger over a decision that has been made. And you want to, as quickly as possible, move into the part of the meeting where you're talking about the separation packet. And that is what you see also on the slide here. If you do take advantage of our mineral product that we offer our clients, there is a California termination toolkit that has all of the separation documents in a nice, neat package. We also have the links separated out here for the notice to employee, the 4-year benefit, and the notice to terminate an employee, and then, of course, the final pay. There's some optional resources there, the termination letter. Sometimes a severance agreement is involved. Those would, of course, be authored by your labor law attorney. And then if you do offer healthcare benefits, then you might fall under Cal Cobra or Federal Cobra, and there's some information on the notices that you'd be required to give on continuation of benefits there. And with that, I'm going to stop and see what questions we might have.
All right. Thank you, Angela. You were so thorough, I think, that we didn't have any questions come through. Either that or we have a quiet group today. But I think one thing that just stood out is employee separations aren't something that should be taken lightly, and you provided a lot of really good best practices and step-by-step practices that we can go about making a separation the safest way possible. So hopefully everybody else feels the same way. Looks like we got a lot of thank you. So no questions. Good job. You answered it all.
Okay, well, thank you so much, everybody, for being here today. And as a reminder, you will be getting a recording of today's presentation, and have a great rest of your day.